Good afternoon. Welcome to this special joint program presented by the City Club of Cleveland and the Federalist Society for Law and Public Policy Studies. My name is David Tryon. I am a member of the City Club of Cleveland and the president of the Cleveland Lawyers Division of the Federalist Society. Many of you know that the City Club of Cleveland is the oldest continuous free speech forum in the country and has weekly and daily programs. The Federalist Society is a nonpartisan organization founded on three principles. The state exists to preserve freedom. The separation of governmental powers is central to our Constitution. It is the province and duty of the judiciary to say what the law is, not what it should be. The Federalist Society also has monthly luncheons with speakers on timely legal topics. For the lawyers here today, today's program has been approved for 1 hour of general continuing legal education. I will announce the CLE number later in the program. As always, our format today will be a presentation by the speaker for about 1/2 hour, followed by brief announcements, and then followed by questions from the audience. We will adjourn at 1:30. Today's program is District of Columbia versus Hellar, the supreme word on the Second Amendment. As we all know, on June 26, 2008, the United States Supreme Court issued its landmark decision declaring the Second Amendment of the United States Constitution to preserve an individual right. Key quotes of the decision have been left on the table in the foyer. Those are the CLE materials for today. The complete decision is available on the United States Supreme Court website. Here with us today to give us his analysis on the court's decision is Gura, who had the honor of presenting the oral argument before the United States Supreme Court. Mr. Gura is a partner in the firm of Gura and Pozeski in Northern Virginia, who focuses his practice on civil and appellate litigation, with an emphasis on intellectual property, constitutional law, and civil rights. Mr. Gura, as I said, argued the case of the District of Columbia in the United States Supreme Court, arguing that the provisions of the Firearms Control Regulation Act of 1975 infringe on an individual's right to bear arms. Prior to forming Gura and Pozeski, Mr. Gura served as a clerk to the Honorable Terrence Boyle, U.S. District Judge for the Eastern District of North Carolina, and later served as a Deputy Attorney General for the state of California, and then entered the private practice of law with the Washington, D.C. offices of Sidley and Austin. In February 2000, he left the firm to serve for a year as counsel to the United States Senate Judiciary Committee, Subcommittee on Criminal Justice Oversight. Mr. Gura earned a BA in government with distinction in all subjects from Cornell University and his JD from Georgetown University Law Center in 1995. In addition to his practice, Mr. Gura has been published in a variety of publications to include the Texas Review of Law and Politics, the Los Angeles Daily Journal, the Washington Times, and the Cato Policy Report. Please join me in giving Mr. Gura a warm City Club welcome.
Well, thank you so much for having me. I was instructed not to discuss the Cleveland Indians or Browns before I came here, so I'll talk about the Second Amendment instead. I'd like to start first with describing why it is that we brought the case. It's important to review the history of this case because I think it provides the context for what the Supreme Court just did. The Second Amendment had always been understood from the time of the founding through about the mid-20th century to secure an individual right of people to keep and bear arms. This was not a controversial matter. It was also not a matter that was litigated very frequently, although there were courts in the mid and late 19th centuries that applied the Second Amendment to strike down certain enactments. The Supreme Court of Georgia in the 1840s, the Supreme Court of Idaho around the turn of the century. We didn't really have much federal gun control. We didn't really have a very robust doctrine of incorporation. And there was not much opportunity to get the matter resolved. In the middle of the 20th century, courts started misinterpreting the Supreme Court's decision in U.S. versus Miller, which I'll talk about in a minute, to mean that the Second Amendment guarantees only some version of a collective right, either what came to be known as the pure collective right theory, which is that the Second Amendment guarantees the right of states to arm militias or the right of people to be in a militia, or what later came to be known as sort of the sophisticated collective rights model when the pure version had problems, which is to say that the Second Amendment does guarantee an individual right to have a firearm, but only in the context of the state militia service. That came to be the latter adopted view. But those two views were the ones that sort of took currency in the federal courts. They took currency in the federal courts in a whole array of cases, which were usually entitled United States versus somebody. These were all criminal cases. The Second Amendment typically was the kitchen sink argument that a drug dealer or bank robber had stuck in his appeal. The courts found it very easy to not examine the Second Amendment with any sort of detail and simply said, well, it's a militia right. You don't have any sort of right here. Go away, Mr. Bank Robber, Mr. Drug Dealer. And so circuit after circuit after circuit, without much thought or analysis, adopted some version of the collective rights test without much question. Well, this all came to an end, of course, in 2001 when the Fifth Circuit in U.S. versus Emerson found that, indeed, the Second Amendment protects an individual right. Emerson did not occur in a vacuum. Emerson came at the end of about a 20-year period where legal scholars had started looking at the Second Amendment carefully in a serious manner. They looked at its history, at its text, at its original public meaning, thought through some of these problems, and started coming to the conclusion from across the political spectrum that indeed the individual rights model was what came to be known as the standard model, and the collective rights models became somewhat the minority position in the law schools and so on. Well, that's the legal academy, but Emerson actually brought the legal theory into practice, at least in the Fifth Circuit, found that the Second Amendment does in fact secure an individual right. It didn't do Mr. Emerson any good because his conviction was upheld, even within the context of an individual right to keep and bear arms. One could still be deprived of the ability to have arms if one was under a court protective order in a domestic violence situation, and so that was pretty much Emerson. But what some people realized, having looked at Emerson, is that the Supreme Court was now going to take the issue head on. This could no longer be avoided. We had not just a profound issue of constitutional law that had really gone unaddressed by the Supreme Court in hundreds of years. It was also a situation where the circuit courts were now split on the topic, and of course the legal academy had debated the matter quite intensely for years. So you had really a perfect storm, a wonderful opportunity to have a case go to the Supreme Court and resolve the meaning of the Second Amendment. Now, what my co-counsel and I believed was that better that the case the Supreme Court takes is one involving law-abiding citizens, not criminals, with careful facts, challenging a law that really needs to be challenged, perhaps handled by lawyers, even if it weren't us, but by attorneys who care about the Second Amendment, want to see it vindicated, not don't see the Second Amendment as some kind of a last chance, thing to throw at the court to try to get somebody, perhaps 3 life sentences reduced out of his sentence that otherwise would be obtained. So we looked around. And we figured out pretty quickly that Washington, D.C. provided the perfect avenue for a test case. Washington, D.C. had the nation's craziest, most draconian gun laws. It still does to some extent. We could not challenge all the laws. But Washington, D.C. did provide us with an absolute ban on the possession of handguns by law-abiding citizens in the home.